I've got a great question for you today. Your case is coming up for trial, and before we actually get there, the attorneys have a settlement conference with the judge. The judge says to me, "Hey, Mr. Oginski, are you ready for trial?" I say, "No, Judge, I'm not. My expert's not available." And now he turns to my opponent and says, "Are you ready for trial, counselor?" He says, "Actually, Judge, I'm not. I'm supposed to go away." He says, "Fine. Both of you go out and pick a jury right now." What? How are you doing that, Judge? Neither one of us are ready for trial. Can the judge do that? You want to know the answer? Come join me on this walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, so you brought a lawsuit against your doctor claiming that he was careless and that his carelessness caused you harm and injury. The defense denies all of your allegations. Your case has gone through the entire litigation process. Now it's 2 years later. Your case is approaching trial. Now the judge calls us both in for a settlement conference to see whether or not there's any chance he can try and settle this case before the need to send us out for trial. So now during this settlement conference, the judge turns to me and says, "Counselor, do you think we can try and settle this case?" I say, "Yes, Judge, I do. I've had conversations with my opponent, and I think there's the opportunity we could try and settle this case." He then turns to my adversary and says, "Counselor, how much money do you have on the case?" And he says, "Judge, I don't have any money." He's like, "The insurance company has refused to give me any money at this point, and they haven't even conferenced the case amongst the principals, so I don't even have authority." And the judge says, "Okay, are you ready for trial?" And I said, "Judge, I'm not. I came in here expecting we would have a settlement conference, and then if we couldn't resolve the case, you'd give us a trial date." He then turns to my opponent and says, "Counselor, are you ready for trial?" He says, "No, Judge, I didn't know that we were going to pick or be ready for trial." He says, "I thought we were coming in for a settlement conference." And you know what the judge says? He says to the defense attorney, "You came in here knowing that this was a settlement conference. You came in here knowing that you didn't have authority to offer a single dime. Yet you're telling me now that there might be the possibility of trying to negotiate this case. So what you're telling me is you wasted my time and the court's time and our resources for absolutely nothing. Is that what you're saying?" And now the judge is getting confrontational with the defense attorney. And he's saying, "Listen, you've just wasted my time because you knew that you were not going to try and negotiate this case, even though you're giving an indication or a hint that you might down the road. Well, guess what? I'm sending you out for trial right now." So what just happened? What just happened is that the judge got so furious and so upset that the defense attorney has wasted his time now with the settlement conference, knowing full well that there was no chance he was going to try and negotiate and had no authority to try and negotiate. In that instance, he goes ahead and says, "Listen, go pick a jury right now." Now the judge knows in his mind that the defense lawyer is not ready for trial. He knows that I'm not ready for trial. What is the benefit of going ahead and telling us to go pick a jury? Well, basically it's to scare the hell out of both of us, because he knows that we can't try this case, at least can't try it now. And because of that, he's now forcing our hand. And if either one of us basically talks back to the judge and says, "Judge, you can't do this. This is not right," you know what the judge will do? He will either throw the case out and dismiss it, or from the defense standpoint, he might dismiss their answers, which means we get an automatic win on liability and causation. And then we would only have to go ahead and try damages. So it is dangerous for both sides now to have to go ahead and argue with the judge about something that clearly should not be happening. So what actually occurs in this instance? Well, what occurs is now both attorneys go out into the hallway, and we have no choice but to go down to the jury clerk to let the jury clerk know that we've been told to go pick a jury, which means that now he's got to bring in a room full of people, and we have to start jury selection. But at the same time, both attorneys now recognize they've got problems. I recognize I have a significant problem. The defense realizes he has a significant problem. And now the attorneys get together because we are both in the same boat, which means we both have problems. There are a number of options to try and deal with this, and none of them are good options. The first option is to go ahead with jury selection. So now we bring in 30 people into the room, and now we start going through jury selection in an attempt to try and select 6 people who can tell us they can be fair and impartial. The second option might be to try and talk to the judge a few hours later. Hopefully we can catch him in a better mood and get him to recognize that this was a harsh decision to tell us to go pick a jury, knowing full well that both of us were not ready to go pick a jury and not ready to try this case. My expert's unavailable, he's going away, there's no possible way we can try this case. But the judge has an ulterior motive. The judge wants to force one side or the other or both to try and get settlement discussions going. That's what he wants to do. And this is a very effective strategy. It's a dangerous strategy for everybody involved, but it puts pressure on me, it puts pressure on my opponent, and you know what? Sometimes this strategy works. Other times we'll have to go ahead and pick a jury and now go in and beg forgiveness from the judge and tell him, Judge, please listen, we need some additional time. I can't do this right now. I'm not the one trying this case, or whatever the reason is. We have to get the judge to try and recognize that this was a rash decision made in the heat of the moment, and please give us another chance. Have us come back in a week or two and give us a trial date so now we can actually go forward if we cannot reach a negotiated settlement in this case. Will the judge do it? There's only one way to know: when it happens. So why do I share this great information with you? I share it with you just to give you a sense of what really happens in these medical malpractice cases, these accident cases, and even these wrongful death cases here in New York. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but haven't done so yet and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.